The tragic story of Alton Waye's death in August 1989 in Virginia's electric chair evokes a deep sense of injustice and sorrow. Despite a myriad of troubling doubts surrounding his alleged involvement in the murder of an elderly widow, Laverne M. Marshall, Waye was executed. Witnesses presented conflicting testimonies, evidence was suppressed, and prosecutors made misleading statements, casting a dark shadow over the legitimacy of the trial.
The brutal nature of Marshall's murder only adds to the heartbreak. She endured unimaginable violence, being raped, beaten, bitten, stabbed 42 times, and doused with bleach. The sheer brutality of the crime highlights the urgency of a fair and thorough investigation to ensure justice is served.
Shockingly, Waye himself turned himself in and confessed soon after the crime, but even this act of honesty did not spare him from the deeply flawed justice system. The fact that initially there was no evidence linking him to the murder only adds to the chilling realization that Waye's conviction may have been based on circumstantial evidence and questionable legal practices.
Testing, 1, 2.
Mine from the governor's office was opened at 2241, is that correct? Okay. This is the execution of Alton Waye. The date is August 30th, 1989. .2253 test of chair completed.
54, I just used 1054.
10.
Confused with the numbers.
Yeah, well that's fine. Whatever's comfortable for you.
All right.
Whatever's comfortable for you. 2254 going in the cell area to read court order.
It's being read at this time.
Okay. Court order is being read. Yeah, I can, believe it or not, I can hear what sounds like Mr. Muncie's voice in the background.
All right. 1056, the court order has been completed.
Okay. 1056, completed reading of the court order.
1057, unlocking the cell.
1057, unlocking the cell.
Are you picking this up?
.1058, inmate is being carried to the chambers.
1058, inmate carried to chambers. Not bothering you, I'm repeating what you're saying so we get a clear shot of it.
That's correct.
Okay.
1058 being placed in the chair.
1058, inmate being placed in chair.
At this time, he's also being strapped in. All the straps are being placed on him at the same time.
1058, inmate being placed in chair and straps applied.
The warden is asking him, do he want to make a statement?
Okay.
I would like to express what about the privilege.
I would like to express what is about to be taken here as a murder. And that he forgives. people who's involved in this murder. And that I don't hate nobody. And that I love them. That's the end of the statement. Did you read that?
Yeah, I'm trying to get it. I would like to express that what is about to take place here is a murder. Did anybody else catch the rest of that?
You didn't get it on?
And something about he doesn't hold that against anyone, and he loves everyone.
That's correct.
I forgive everyone and I love everyone.
That's correct. At this time, the headpiece is being placed on the inmate.
Okay.
Let me rephrase that. At this time, the headpiece and mask is being placed on it.
Headpiece and mask.
Can you hear me?
Yeah, you're fine. And I've got about 11:58. Looks like we may have jumped.
11:59.
11:59. 10:59. Okay. We have to doctor that up.
At this time, at 11:59, the minister is saying a prayer.
Minister is saying a prayer?
Can you hear me okay?
Yeah, we're doing fine. Minister is saying prayer.
Trying to talk low.
Yeah, you're doing fine. Doing fine. You're coming through loud and clear.
They're wiping the sweat off of his forehead, his arms, and his feet.
Okay. Off forehead. Wiping sweat off forehead, arms, and feet.
Correct.
Okay.
The key has been placed into the proper position.
Key placed in proper position.
And turned on by the warden in the nod. And execution is taking place.
Okay. Eleven even. Key placed in proper position, warden nod, and execution is taking place.
11 even.
Okay. Wayne gives these folks this info. Get Mecklenburg on the phone and give them the info.
Second Job, 1101.
Okay. 1101, what was that?
Second Job, 1101.
Second Job. Okay.
Completed at 1102.
1102. Completed. We can hear a few protesters in the background. I just heard. The first time I've heard anybody. Debbie Groom says she's heard them on and off for about 15 minutes, but that's just for your information. The last statement, as best I have it, Mr. Lawson, is I would express that what is about to take place here is a murder. I forgive everyone involved and I love everyone involved. That's the best that I can relate to what you told me of what he said.
Yes,
that sound about right? I don't hate anyone and I forgive everyone involved. I think that's what he said. Maybe the love thing was not in there.
Yeah.
Okay. I don't hate anyone. Anyone. I forgive. Yeah, we still here. Still here. Still here. Still holding on.
Excuse me, 1104. Shirt is being pulled back for the examination of the doctor.
Okay. 1104, shirt pulled back for examination by a doctor.
1105, doctor's examining. 1105, he has been pronounced dead.
Okay. 1105, doctor examined and pronounced dead. Okay.
1105, the curtains are pulled.
Okay.
And the witnesses are leaving.
And witnesses are
1105.
1105. Okay.
Do you need anything else?
I don't know of anything else.
No.
I'm going to get ready to go do my thing.
That's it then.
You great. Thanks.
I turn this on.
Okay. Get that.
Amidst Alton Waye's legal battle, his defense attorneys presented compelling arguments that raised serious doubts about his confession. They highlighted various medical factors such as brain damage, borderline retardation, intoxication, and drug use, which could have influenced the reliability of his admission. Additionally, they unearthed new evidence that had been suppressed, further undermining the state's case against him. In court documents, Waye's legal team emphasized that considering all the information now available, these false impressions merely scratched the surface of a much larger issue, the presence of substantial doubt regarding Waye's guilt in the capital murder for which he was convicted. With his execution imminent, these assertions shed light on the pressing need for a re-evaluation of the case to ensure justice is served correctly.
Waye's confession led to a one-sided investigation. Len Gooden, his cousin and key witness, was overlooked despite evidence suggesting his involvement in the crime.
J. Lloyd Snook III, who represented Waye, said, "I think by the time it got to the jury, they were so mad at Alton Waye because they saw the bloody photographs that they wanted to put him away. For whatever it's worth, you had a young black man accused of raping and killing an elderly white woman."
In a startlingly short amount of time, the jury found Alton Waye guilty and sentenced him to death, unaware of critical evidence that could have challenged his guilt. Semen found on the victim's body could have come from either Waye or his cousin, Len Gooden, but this information was not presented in court. The prosecution claimed that semen on Waye's clothes proved his guilt, but it could have had alternative explanations unrelated to the rape.
Similarly, hairs found at the crime scene were merely identified as belonging to a black person, not specifically to Waye, leaving open the possibility that they could have been Gooden's. Disturbingly, inconsistencies emerged regarding Gooden's account of Waye's alcohol consumption before the murder. While Gooden initially mentioned Waye consuming 6 pitchers of beer and moonshine, he later testified that Waye had only a few cans of beer. Prosecutors failed to address this inconsistency, and even a police officer's statement regarding Gooden's disclosure was disregarded.
Waye's lawyers sought to postpone his execution in order to establish Gooden's potential involvement, highlighting the need for a more thorough examination of the case. The suppressed evidence and misleading statements by the prosecution paint a troubling picture of a trial marred by significant gaps and potential miscarriage of justice. Len Gooden's background reveals a startling pattern of criminal behavior. Not only did he have a history of breaking and entering, but he was also arrested for a similar offense during the period between the murder and Alton Waye's trial. The plot thickens further as Gooden later faced conviction in Michigan for raping a white woman and became a suspect in a series of violent rapes in the same area. Intriguingly, the string of rapes abruptly ceased once Gooden was imprisoned, as detailed in court documents. These revelations cast a significant shadow of suspicion on Gooden and raise compelling questions about his potential involvement in the crimes attributed to Waye.
In an August 1989 affidavit a dozen years after the murder, a Michigan lawyer, Richard A. Neaton, said he interviewed Gooden and believed he had a role in the crime.
He came very close to confessing to breaking into the victim's house and to committing the rape. I am convinced, based on my experience as a prosecutor and as a criminal defense lawyer, that Gooden was in the house that evening and was not in the car asleep as he testified at trial.
In a disheartening turn of events, the Supreme Court, with a 7-2 majority, cleared the path for Alton Waye's execution, rejecting appeals regarding faulty jury instructions and Waye's mental competence. Justices William Brennan and Thurgood Marshall dissented. Earlier, the Fourth U.S. Circuit Court of Appeals also denied a stay of execution, disregarding the request for more time to investigate the potential involvement of Waye's cousin, Len Gooden.
The 3-judge panel at the Court of Appeal rejected the arguments, saying, "There must be some finality, and the final stage has been reached in this case."
Waye's attorney, Gerald Zirkin, expressed frustration as the Virginia Supreme Court declined to review crucial evidence due to its absence in the original trial. In federal appeals, the exclusion of psychiatric testimony couldn't be raised as it fell under the jurisdiction of state evidentiary rules. This limitation hindered the presentation of critical information in Waye's defense.
Alton Waye's case stands as a painful reminder of the imperfections of the criminal justice system and the devastating consequences that can arise from wrongful convictions. It leaves us grappling with profound emotions of frustration, sadness, and a burning desire for justice to prevail.